And our top story, the victims, the church, the silence. Who's to blame when both sides keep quiet about sexual abuse?
Now, Margie Reedy, Chet Curtis. This is Newsnight on NECN.
Boston's Bernard Cardinal Law makes a point of offering to be available to victims of sexual abuse by priests. No doubt today's meeting in a downtown law office was not what he had in mind.
Alleged victims of Father Paul Shanley were in the room as their attorneys questioned Cardinal Law under oath. The deposition continued for hours, and this latest round is far from over. NECN's Lauren Matalon has the story.
The parents of one alleged abuse victim of the Reverend Paul Shanley's sat in on Cardinal Law's deposition. Paula and Rodney Ford, the parents of Gregory Ford of Newton, Massachusetts, say listening to the deposition was both revealing and painful at the same time.
And you know what? For a person in a position of authority, I don't really know what he did, because he told everybody else to do things. What did he do? That's what I would like to know. I know what he didn't do. And what he didn't do was to put the interest of children first.
He contradicted himself.
Strongly implying that the Cardinal was less than truthful with the deposition, Rodney Ford said that he was very hurt as the story of what allegedly happened to his son was unraveled.
And the biggest point that I got out of this today was what Bishop McCormick said. He didn't want to create a scandal. Like I repeated the other day, this is a scandal at its highest, and he will have to answer to it.
He really tried to answer the questions as they were posed.
Boston Archdiocese spokesperson, the Reverend Christopher Coyne, says the Cardinal was questioned about his activities dating back to his time as a priest before becoming Cardinal. The Reverend Coyne said Law was unable to recall all details, but gave substantive answers to many questions.
He said even though he had people working for him making decisions, he accepts full responsibility for those decisions as they were made.
Now that is the main bone of contention between the two sides. The Archdiocese, as you just heard, was very emphatic about the fact that the Cardinal did not apologize, but did accept at least a measure of responsibility for decisions that were made, for reassignments that were made. On the other hand, the Ford family categorically denies that. They say that no such set of words was echoed inside that room, and they say they're very disappointed as a result. Both sides, again, expected to meet, scheduled to meet on Friday. Lauren Matalon, NECN in Boston.
Now, there's a new controversy in the latest round over the legal battle over sexual abuse claims.
In some cases, abuse claims were settled, the terms were kept secret, and the priests later were charged with more abuse. So who is to blame in such cases? Our guests tonight include Philip Saviano of SNAP, the survivors network of those abused by priests. Also, attorney Paul Kelly, a former federal prosecutor, and Professor Robert Bloom, who teaches at Boston College Law School. His latest book is Ratting, the Use and Abuse of Informants in the American Justice System. Thanks to all of you for being with us tonight.
Thank you, Margie.
Phil, let's start with you, because you have been in this situation, and you have had to decide whether to sign a confidentiality agreement or not, and you chose not to.
Right.
Do you think that they protect victims, or does it make things worse?
Oh, it doesn't protect victims at all. What it does is it forces victims to enter into that vast web of secrecy that the church has used to hide these crimes for so many years. I've never heard of a victim who is asked to be part of a confidentiality agreement. On the other hand, lawyers, not only the victim's lawyers, but the church's lawyers, always try to encourage the victim to go along with it. In my case, before I even had the document presented to me, I said to my lawyer, I'll settle this case, but I'm not going to sign any sort of confidentiality agreement. And I still was faced with a document that would have prevented me not only from discussing the specifics of my case, but discussing anything that has to do with the issue of priests molesting children.
Is that true? You're saying that a lot of victims don't want this. And I understand just from hearing of the different lawyers who've come through, they said, you know, a lot of these victims are very fragile, they have substance abuse problems, they have things or they just simply don't want this put into the public.
Well, I think, you know, confidentiality clauses are used all the time and have been for decades. They're used not only in these types of sexual abuse cases, they're used in product liability cases, in any time a defendant wants to conceal something that, you know, is detrimental to their cause. You know, in this instance, I think dating back to the 60s and the 70s, I think there were a lot of victims, a lot of families, perhaps not like Phil, who didn't want to sign a confidentiality agreement, wanted to preserve his First Amendment right. But the flip side is true. I think there is a fair number of people who didn't want that public shame, didn't want that public embarrassment, and frankly instructed or requested of their counsel to keep these quiet.
So doesn't that put some lawyers between a rock and a hard place? If their clients insist on a confidentiality agreement, the lawyer has no alternative.
Absolutely. The lawyer has to represent his client zealously and just focuses in on his client. So if indeed his client wants a confidentiality agreement, then the lawyer has to strive for that. In addition, my guess is that the church made it more agreeable for the attorneys and the client to accept these confidentiality agreements by offering greater sums of money. And that's up to the client to decide whether or not they're willing to do that.
Yeah, what about that, Phil? I mean, you said you haven't heard of many alleged victims or victims of abuse who were asked about that.
Right. I haven't.
But can you imagine that some may have along the line that just for whatever personal reasons they may have just didn't want their names public?
I think that it's possible that lawyers have presented this to victims in such a way, said, look, if you agree to be silent about this, you get X number of dollars. Some victims may have gone along with that, but I don't think that it ever originated with the victim. The other important thing, though, is by signing that sort of agreement, not only does it protect the church, protect the criminals, but it's also emotionally harmful to the victims. Because the last thing that you want to do is force a victim to be in a position where they can't talk about this. They're never going to heal, they're never going to get over it if they have to keep it bottled up.
I'm wondering if there was also an evolution in these cases. I mean, if this had happened 20 years ago, could this have exploded as it has today, or has this been a sort of step out of the darkness and into the light of public scrutiny?
If what had happened 20 years ago?
All of these allegations. I mean, would people have come forward and have very publicly made these allegations, or has there been sort of a movement against these abusers that has taken some time to sort of rout them out, if you will?
Well, I can only speak based on my own experience in the Worcester Diocese. I mean, I came out with a story about Father Hawley in December of '92, and then there was a flood of other allegations about other priests within the Worcester Diocese. And it went on for 2 or 3 years, and almost everybody that came forward, if they decided to file a lawsuit, they all were faced with this document, and everybody agreed to it.
So you're saying it could have
signed
happened a lot earlier had these not been in place?
Yeah, and the other thing is that now what's happening is that the reporters at the Worcester Telegram and Gazette, for example, who are trying to understand the history, they can't find anybody to talk to them because everybody's under these confidentiality.
Yeah, but it's true that some of the people who came forward just recently, who were emboldened, if you will, by the fact that other people were coming forward, some of them didn't know that, there was, we've talked to people who said, I thought I was the only one or one of a few.
I think there's no question that confidentiality clauses perpetuate the shroud of secrecy, not just in the church cases, but in all types of cases. It almost always originates with the defendant, the corporation, the archdiocese, the person that has something to hide. And there's no question that the archdiocese had a lot to hide here. Their lawyers certainly knew, to a greater extent than the plaintiff's lawyers, the extent of the problem. But did the lawyer have an obligation to, instruct his client not to sign a settlement agreement unless the confidentiality clause was stricken? The answer is no.
What about that, though?
Well,
I mean, do lawyers have any culpability in this for hiding these crimes, for judges for signing off on these agreements for so long?
Well, lawyers were focused in on their clients. But with regard to Chet's question as to whether or not these contracts are now enforceable, and that's in essence what they are, is contracts. These contracts, now that we know what we know, are against public policy. We cannot let the public know about what's happened in the past. This is to protect the public. So it's very unlikely that there's any judge, at least in this Commonwealth, that would enforce one of these agreements at this point.
But what's the obligation of a judge or an attorney who knows that a crime has been committed? As an officer of the court, isn't there a responsibility that he or she they have to report it?
Well, the fact is there was no I did it or I didn't do it. There was no specific statement. There was allegations that a crime had been committed. And at the time, sexual abuse did not have to be reported by the clergy. So it wasn't clear that a crime had been committed. I might point out, though, however, that the church's lawyers were seeing a lot of these kinds of agreements. So unlike the plaintiff's lawyers, they might have seen a real problem here.
They did know the scope of the problem.
They might have known the scope of the problem. And as counselors, not just attorneys representing their clients, it seems to me, and maybe they did this, I don't know that they didn't, had an obligation to tell their clients, hey, we've got a problem here and we need to address it.
There is a rule that governs the conduct of lawyers that says that if you've got an obligation of confidentiality, but if a client comes to you and reveals information that he's about to commit a crime or about to perpetrate an act which is going to lead to some substantial injury, that relieves you of the burden of confidentiality and you have actually an obligation to disclose it. I think an argument could be made here that if you had a plaintiff's lawyer that knew that there was this rampant sexual abuse and that by agreeing to confidentiality clauses, you were going to send some priest out to another diocese to commit crimes again or to commit these acts of pedophilia, I mean, there is the public policy reason which he makes reference to, I think, does apply. Do we have a higher moral calling than just this isolated case?
Well, Phil, in a lot of these agreements, though, they were mandated to pull this priest out of service and send them to treatment. And I think that's why a lot of these lawsuits have now been filed, is because that confidentiality agreement and the settlement agreement terms were violated because the priests were not being pulled out of service.
Right. The other thing, I think it's important to note that there's a lot of blame that can go around, and everybody's been on somewhat of a learning curve here. I think that lawyers on both sides have to take a little bit of responsibility for contributing to the cover-up, as have judges, because a lot of the cases that were settled in court and the judge instituted a confidential seal on the case, they shared some of the blame as well.
Yeah, but on the other hand, none of these allegations were adjudicated. They were merely, I say merely, they were allegations untested in a court.
In a criminal.
In a criminal
judge
court.
has two lawyers on each side of the case, and he sees that these two lawyers are competent and they are agreeing on behalf of their clients. So the judge is sometimes in a difficult position, and they want to move cases along, and this is the way to resolve a case.
All right, we need to hold right here for a moment, take a break. We'll be back to continue our discussion on Newsnight after this.
I thought the mood was very professional. I thought that Mr. McLeish was very courteous in his questioning and very straightforward in what he asked. And I thought the Cardinal was very honest in responding to the questions, coming forward to the best of his recall and the best of his ability.
The latest deposition of Cardinal Bernard Law comes just as newly released documents highlight his role in transferring priests accused of sexual abuse of children.
Tonight we're looking at a controversy that involves the church and the attorneys who settled sex abuse cases under terms that required both sides to keep quiet about the abuse. And Phil, as you noted during the break, the U.S. Conference of Catholic Bishops has promulgated a series of steps that they're going to vote on in Dallas next week. And at least as concerns sexual abuse cases by priests, there will be no more confidentiality.
Yeah, and as far as I'm concerned, that's a major development. For them to say that from this point forward, we're not going to enter into any of these confidentiality agreements is a big step towards ending the secrecy. Now, they could take it one step further and do as Cardinal Law has done and as Bishop Riley has done in Worcester recently, which is say anybody that signed one of these in years gone by is now free to speak. But at least from this point forward, they're taking the step, and I applaud them for that.
I think that whether the Catholic the bishops had done that or not, that in this context, confidentiality clauses are a thing of the past, because I don't believe that the victims, now that the light of day has been shown on this problem and the extent of this problem, I don't think the victims or the plaintiff's bar or the public would tolerate confidentiality clauses.
No, but they'll always be a part of our legal system, I would, in other cases.
They will. But it's hard for me to imagine a judge sanctioning these confidentiality clauses, given what they know.
Have they served a purpose along the way to bring this out, to make the Archdiocese sort of ratchet up the level of accountability here, or should they just not have been done ever?
I mean, I think the Archdiocese should have been quicker as part of the recent activities to agree to relieve plaintiffs that have settled past cases from the obligation of secrecy. They haven't yet done that, to my knowledge. Clearly the Archdiocese bears the largest responsibility, and its lawyers, for insisting on these confidentiality clauses and refusing to settle most of the cases without them.
But what if an alleged victim comes forward now? This is, 15, 20 years later, and for whatever reasons does not want his name public and insists to his attorney that he wants a confidentiality agreement. What does the attorney do?
That seems to me part of the negotiations with the other side, and certainly if they're willing to abide by it, the question is whether or not they could be enforced. So if they change their mind, they can go forward, because I can't see them being enforced.
You can always file a lawsuit as a John Doe or Jane Doe. And certainly the news media seems to be reluctant to publish anybody's name unless they're willing to be identified.
Right.
So I think that there would be a way to do it. But, something like this, which would even, in my case, I even wanted my therapist to agree to confidentiality terms, is a bit much, I think, and not at all. Clearly, they didn't have my own emotional well-being as their first priority.
Talk about that for just a second, because you talked about how this is bad for victims, and I know that there's a lot of shame surrounding this sort of instance anyway with abuse by a priest. How does this fuel that?
Well, it fuels it because, first of all, it prevents the victim from reaching out to other victims, for example, for going to a support group, or to learning about what happened to them, or getting advice from somebody who's gone through a similar experience. It sort of puts the victim back at that point when they were a kid and they didn't have the courage to tell anybody about it. And I think emotionally it's very harmful.
Talk about, go ahead, Paul.
I was going to say, the lawyer, as a counsel, the role of the lawyer is to take the client as it finds them, and maybe if it's got a client like Phil, who has this desire, this overwhelming need to speak out and deal with the issue, then in that instance, the lawyer's obligation is not to sign a confidentiality clause or recommend one. On the other hand, if you get other clients that don't want the public humiliation and the battle in court, I think your obligation, again, your client is your first and foremost consideration, and then I think you would advise him or her to go along with it.
Yeah. Professor Bloom, another sort of ugly side that's been brought out about this, people are accusing some of the attorneys who are representing victims and alleged victims of saying, you're in this for the money. You're doing this because there are large legal fees that are attendant to a settlement that may be very long in coming when it comes to a lawsuit or may never materialize, and that's the motivation.
These are tough cases, and the attorneys are entitled to earn a living. And these tough cases, when you're going against an institution like the Archdiocese, it's costly. And the way they're able to get paid, because the victims often do not have the resources to pay attorneys. So they have this contingency fee basis where they get a percentage, unfortunately, of the victim's reward and or settlement.
Mm-hmm. But most of this takes so much time, and the lawyers are expending money with depositions, with investigations, and none of it's coming in.
That's the other possible advantage of a settlement in advance, because then you know what's going to happen. Without the confidentiality piece, these settlements would be a good way of limiting further embarrassment to the church and possibly to the victims of these horrible acts.
Do you want to speak to that?
Yeah, I just want to say, in Massachusetts, it's all based on secrecy, and that's been supported by charitable immunity as well. For example, lawyers know that if they go to trial, the most that's going to be awarded is $20,000, because that's what the cap is here in Massachusetts.
There's a big question about that.
So there's no point in going to trial, from a lawyer's point of view, if you're looking to make a living doing this. And that's worked to the church's advantage, because they can say, well, then we'll give you a little bit more money, sometimes substantially more money, as long as you'll agree to keep the secret and sign this confidentiality agreement.
But that whole immunity thing is going to be challenged.
And now the secrets are out. So there's no point, I think, from the church's point of view. They can say, well, why not go to trial? Because the secrets are already out there.
Phil makes a very good point, but again, in terms of contingency fees, I mean, usually these cases, they drag on for years. Lawyers expend lots of money doing them. Usually they're difficult cases, again, involving unfavorable public causes. I mean, these lawyers that have been out in the trenches now doing these cases for 10 and 15 years, I mean, they deserve a lot of credit. I mean, people can criticize them for making money, but they bore a lot of these expenses. They put a lot of time and effort into it, and they deserve to be compensated.
All right. right. Thank you so much, everyone, for being with us tonight. Our guests, Phil Saviano, Attorney Paul Kelly, and Professor Robert Bloom.
Coming up, was it science, a hoax, or both? The story of an 18th century chess-playing robot, the Turk, when Newsnight continues.